minutes to join more participants, and then we can begin. All right, let's get started. Good afternoon, everyone, and thank you for joining us today. Welcome to our webinar from checkboxes to return of investment, turning PDPL consent into a competitive advantage. So this session is proudly hosted by CyberWaze in collaboration with our valued partner Ardent. My name is Mohammed Rehan, and currently I am leading GRC services at CyberWaze, and I will be your host and moderator for the today's session. Now, today's session will be focusing on the data privacy and regulatory compliance. As organizations across Middle East is expanding and accelerating this transformation, we are also seeing a significant shift towards data protection regulations, particularly with the frameworks like PDPL in the UAE, KSA, and Qatar. In today's session, we will be exploring why the traditional consent practices are no longer beneficial and sufficient, how organizations are getting wrong in the execution of the data privacy regulation, and the most important stuff for the business executives and the board of directors, how consent can transform into a return of investment. I'm very pleased to introduce our expert speakers for today's session, Mr. Samir, founder and CEO of Ardent Privacy, and Sakshi Agrawal, privacy analyst at Ardent Privacy. We are very excited to have both of you to share your experience and practical insights with us today. Without further delay, I will be handing over to Samir and Sakshi to get started. Over to you, Samir and Sakshi.
Thank you so much, Rehan, for having us here today. Let me quickly give them a context of why the session is important, because we are seeing in different regions of how consent is being played and how we need to work around it. So let me quickly introduce my team, Ardent here. So what we are going to discuss today and how we have the expertise to do so. So at Ardent, our mission is to help enterprises and government agencies to implement meaningful security and privacy programs. And we do it in a way that it helps the organization uh, in aligning with their business mission, building trust with their customers. We have been reviewed by S&P Global and Gartner. We have recently been awarded by Cybersecurity Association as well. Just give me a moment. Yeah. Sorry for that. So we have been trusted by various different partners that we have, and we are backed by the Data Security Council of India. We are backed by BWT Tech and TEDco back in US as well. We have been trusted by our customers, which is one of the largest private sector banks in India, HDFC. We have Hindustan Petroleum, and then we have Z Entertainment. So we have various different sectors of clients. We are headquartered in the United States. We have a heavy presence in the Middle East, and we have a dedicated office and support in India as well. So now what we have also seen is that there is a confusion around what exactly security is and what privacy is. So there is a confusion in understanding and addressing this issue. So before moving forward, let me clear that up for you with an analogy. So think of your organization's data environment as a house. And if there is a house, you would have put your doors there for security. You would have put up your windows. You would have put up a lock there. So all of these things help you in keeping out the bad actors. It protects your house from being broken into. And yes, it is absolutely essential. But then what is privacy, you might ask? So privacy would be the curtain that you have on your windows or on your doors, and that is how you protect. So even the strongest lock in the world that you might have and cannot protect your privacy if your curtain is open. Anyone walking by can see exactly what is happening inside, what you own, what is happening, how do you live. So for that reason, the privacy and security distinction is very important. And in this context as well, as we will be discussing consent today, because you'll have to understand that you might have world-class cybersecurity infrastructure in place. You might have your firewalls, you might have your encryption, your managed controls, and RBACs implemented, but you would still end up violating someone's privacy if you have not taken their consent properly. Security would be protecting data from the threats, but privacy gives any individual or a data subject the control over their data. And that is exactly what organizations need to understand today. Both are non negotiable, they are not the same thing, they are trying to solve different aspects of the data. And I hope you keep this in mind before we move forward here. So to address this issue, we have come up with a 6 steps implementation plan as well, or execution plan of how you can handle the privacy aspects through Total Shield, and what are the things that are required to be done by you. So as an organization, for the privacy compliance, what you need to do is that you need to take up various different kinds of assessments. So you need to take up your data protection impact assessments, or your privacy impact assessments, or your transfer impact assessment, whatever the case may be. And the assessment manager module that we have here helps you in carrying that out. It acts as a single source of truth for you and for your organization to understand where you stand in your privacy journey. Then comes the data discovery and intelligence module. What it helps you in doing is that it will help you in knowing exactly where the data is lying. So it helps you in identifying various structured, unstructured data, where is the data lying. It does auto scanning, and while scanning itself, it classifies data also into various different categories. Is what kind of data is it? Is it PHI, PCI, PII? Whatever the case may be, it will give you a visibility over the data so that you now know exactly what you need to protect here in this case and in terms of privacy. Then comes the data subject rights management part. We have various different rules and regulations here today. But how, and all of them are giving certain rights to the data subjects. So, how do you, as an organization or as a data controller, manage these rights? How do you implement these rights for the data subjects to actually access it and to be able to exercise those rights with you? So we do have a dedicated workflow for that as well, wherein they can come up, exercise their rights or fill a form for you, wherein they can register the request with you, and then you as a data controller can work around it also. Then comes the consent management. Consent management is something that we would be discussing in detail also further today. What our consent management system helps you in doing is that it helps you in creating a centralized system for consent. So it will help you in collecting the consent, storing the consent, managing the consent, and actually proving to the regulator that you have taken these steps for consent management in place. Then we also have data minimization or storage limitation. So that is there because once you have taken someone's data, it does not mean that you can store it for perpetuity. You will eventually have to go ahead and delete that data. So for that reason, we do have storage limitation in place as well, wherein you get a visibility over how much data is above the retention period, and you should go ahead and delete it if the purpose is already solved. Then comes the data breach management aspect of it as well, because privacy is of utmost importance, and in case a data breach takes place, then the privacy of the individuals are in picture here. It is of utmost importance. So at that point of time, you will actually have to go ahead, tell the regulator that a data breach has taken place and that they need to work around it. And you, as an organization, also need to work around it. You have to cure that particular breach that has taken place. Then we have, after various meetings and discussions that we have had, we have identified what organizations are struggling with today. So, what we have seen is that there is a lack of data or sensitive data and intelligence in any organization because they're not able to understand what exactly do they need to protect. Then there is an AI compliance fatigue as well because there are bottlenecks which are created due to the lack of this visibility. Then we have tedious manual compliances process in place as well because of the lack of a system or a lack of a better way to deal with all of this. It has been happening through manual compliance processes, and it is prone to errors, and it works in silos, which is also not feasible in long term for that particular organization. Then there is a huge consent conundrum around it because people or organizations do not know how to manage this mammoth task that is consent. So they have to work around it as well. And in general, we have seen that there is a roadmap crisis in the organizations of how do they actually deal with privacy, regulations, compliances, and all. So for that, let's now jump a little bit into the regional privacy landscapes that we have and how we are present today geographically and regulatorily. So we have seen that the GCC region is undergoing a fundamental shift in data privacy for that matter. And this is not a future concern anymore for anyone, right? It is happening right now. and regulators are active now. Enforcements are getting real, and privacy awareness amongst customers are also increasing day by day. And the organizations are not actually prepared for it. They are not ready to take on all of this. So, today, for that reason, we will be covering specifically the consent requirements under three major frameworks. First will be Saudi Arabia's personal data protection law, which is one of the most comprehensive data privacy regulations in the region that I have seen. It has strict requirements around consent and especially around sensitive data. Then we have UAE's Federal Personal Data Protection Law as well that we will be discussing today. It will be focused more on clarity and your ability to prove consent. I will take that up a little bit later. And we will also be discussing Qatar's PDPL, which is more centered on prior and express consent with some contextuality to the flexibility in some limited cases as well. So these three countries, three laws that we will be discussing, do have significant overlaps with each other, but it is also important for us to understand the differences that they have and what does an organization need to do differently who is working across or operating across borders. What do they need to understand? So let's try to understand that by going a bit into the basics. So let's first understand what is consent and what is explicit consent. So at its very core, consent is basically an agreement which is very clear, informed, and purpose specific by any individual or a data subject for that matter to allow you as a data controller to process their personal data. Now, how does it happen? That it will happen so that it needs to be very freely given, which means that it should not be buried in, for example, 40 pages of terms and conditions document. It needs to be very specific. It should not be a blanket agreement wherein you have taken consent for everything that you might ever want to do with someone's data. And it also needs to be informed. By that I mean is that the person should actually understand what they are agreeing to, or at least what they are expected to agree to, and it should not be filled with legal jargons, for example. So if this is consent, then you might ask me, that's actually what is explicit consent. So all of this included in explicit consent is that we take all of that, plus we take a step further. We take and see that it is a stronger type of consent, which is more direct, and it is an unmistakable form of an agreement by any particular data subject for you. So, in that, what happens is that you, as an organization, can actively demonstrate and prove that yes, it was not an implied consent, it was not an assumed consent, it was actually expressed by that particular data subject that yes, I am giving you my consent. We have documents for it, and we can defend ourselves that yes, this particular kind of consent was taken from them. A very simple way to remember this is that consent is a very clear permission, but explicit consent is somewhere that you have expressed and provable permission for that consent for any particular purpose of that data subject's data. Now, the word provable here is also doing a lot of heavy lifting, let me tell you that, because it is precisely where most organizations are falling short, what we have seen today, because they are thinking that just putting a simple cookie banner or a consent banner that way will help them in complying, which is not actually correct. There is much more to consent than just a simple cookie banner for a valid consent to take place. Let's understand what is the requirement under these three different laws now. So let's first see for UAE. So what does UAE's PDPL law expecting you to do? This requires a very specific consent to be taken by the data subject. It should again be clear in nature, it should be unambiguous, and it should be provable. Now I will emphasize here on clarity because Again, it is important for the data subject to understand what are they agreeing to, and you as an organization or data controller, your ability to demonstrate that the consent was indeed properly taken by that particular or from that particular data subject, and no implied consent was taken, because let's be honest, if you have taken an implied consent, it will not hold up in your audit purposes or your scrutiny if it takes place for your organization. Then comes Saudi Arabia's PDPL. So now how this differentiates is that for PDPL under Saudi Arabia, it is applying a little more stricter standard to this consent requirement. It is particularly asking for consent for sensitive data categories. In many cases that we see under PDPL here, is that there is a need, and what KSA PDPL needs is that effective functions need to be there. So effective functions as explicit consent or by consent by default should not be there. You should have a demonstrated purpose for that. There is a strong emphasis on documentation here again in Saudi. Then if you cannot show the regulator basically what is the record of flow, how and when did this consent come to you, for what purpose was this consent withdrawn, obtained or withdrawn, you will be exposed to a lot of scrutiny in the region. Then comes Qatar's PDPPL as well. So what this requires, it is a bit different. So it requires the consent to be prior and express in nature. It means that it must be obtained before the processing begins of the personal data of any individual. There is some contextual flexibility, as I was explaining earlier, which can be acknowledged, but it is very limited and it is in very limited cases. But the baseline expectation is always clear that it should be that you should ask before you act for processing of anyone's personal data in this region. So if I have to summarize it now in just one sentence of these three regions, UAE is demanding clarity from you and your ability to prove it that you did take valid consent. Saudi is demanding the strictness and documentation for the same, specifically for sensitive data also. And Qatar is demanding timelines and the expression of how are you going to handle the consent regarding and around this region. Now, we are talking so much of consent, this and that, but why exactly is it required? Why is it the cornerstone? We have not discussed that yet. So, let me discuss that with you as well. So, why consent is the cornerstone is that we have seen that consent is one of the primary legal basis for processing personal data. In most of the cases that we have seen, that most of the scenarios under most of the frameworks, you have consent as one of the primary legal basis. And without it, your data processing that you are doing, no matter how well intentioned that is for you, it will lack the legal grounding. And if you have taken the consent of any particular data subject, you are also ensuring and showcasing transparency to them. When you ask for a proper consent from any particular data subject, you are telling your customers exactly what you are going to do with their data. That is also going to help you in building trust and bringing or driving more business for you. Then we also have how it is enforced in both directions, right? So it is not just that it will help you with your customers, but it is for your compliance also, because your non-compliance will carry certain penalties for you, your financial penalties. There would be a reputational damage for you as well. And in some cases, it could be that you might get restricted for operations. But if you have a proper compliance in place, and it also gives you a defensible position If you are ever audited or challenged that yes, you have proved that you have taken consent properly, then you're going to be good in most of the cases. Now let's also discuss what goes wrong in practice, right? So let's be honest here. We have talked so much of what needs to be done, but what exactly is something that organizations are not doing or are they failing to do? Because most of the failures are not about intent, right? No one wishes or intends to fail in compliance. It is just that they are failing in execution part of it. They are not able to understand that they are actually violating privacy of an individual. So how is that happening? They are, even though they are taking consent, somehow in some cases what they might be doing, and the most common failures that we have seen is that they are maybe taking bundled consent. So what does bundled consent mean? Maybe they are trying to take consent just by one checkbox, for example, that is covering your marketing, your analytics, your third party sharing, profiling, and any other kind of consent also, which you should have ideally taken separately to show or demonstrate that yes, you have taken consent for various different purposes here. Then because regulators see right through it, right? Because if you have taken bundled consent and the regulation is saying that you should take consent for each purpose, they would see right through it that you have just combined all of it, taken consent once so that you are able to use it as an organization. So if you can't isolate what someone agreed to and you cannot show that to the regulator, then you do not have a valid consent in that case. Then there are confusing legal jargons as well. So privacy notices are again very honestly written by lawyers and for lawyers also so that they can prove it in court. But that does not mean that it needs to be heavy with legal jargons. So if any average user is reading a consent notice which has been drafted by me, for example, and if in about 8 seconds they have not been able to understand what am I trying to convey to them, if the person sitting across that particular consent notice needs a legal degree to understand what I have written, I have failed in my job. I have not been able to put a privacy notice that they are understanding. Right? So the key here is that the notice that is being presented to any data subject here should be very simple in language. They should understand exactly what they are agreeing to, and I and it should not be loaded with legal terms because they would not be understanding it. It should be very plainly and directly told to them, this is what we will be taking, this is what we will be doing with your data, this is how we'll be sharing it, and then they can give their consent accordingly. Then we also see that there is a lack of audit trail because again, as I was explaining earlier, that people have relied on manual compliance processes or have not understood the importance of consent. So there is a lack of audit trail, and which is a very critical aspect that you should have in place. If a regulator comes today and asks you to prove that a specific individual, so, for example, if a regulator comes and asks you, did Sakshi give her consent on a specific date? Did she give it for a specific purpose at this particular time? Can you, as a controller, answer these questions to him within maybe 60 seconds? If not, as most organizations cannot, then again you do not have a good consent practice in place. We also have seen that there are weak withdrawal processes in place in the organizations. So what I mean by that is that if you are taking consent, for example, very simply to from a person, then does that person now need to send you maybe 3 emails, drop you to WhatsApp messages or maybe need to call you, and then still have to wait for 30 days, and only then will they be able to withdraw their consent. If that is the case, then again you have failed as a data controller, because consent needs to be withdrawn as easily as it was given by that particular data subject. So you should have such processes in place wherein they are able to opt out as easily. And again, the regulators know it, right? So if they go ahead and see that, okay, this person has given their consent this way, now how can they revoke their consent? If you tell them that now we'll have to go ahead and send 2 3 emails, you are failing in eyes of the regulator then and there. The last one that I want to discuss now is what organizations see as one size fits all consent flows, right? So the same consent banner that you have, you cannot implement it across different regions or across different countries, because each country's law is required or requires you to do something completely different. So your consent banner or your notice for Saudi Arabia or UAE or Qatar or any other country, for example, cannot be cross uh, implemented. You will have to actually make adjustments, make the jurisdictional differences put in place. You will have to put all of that in place. And then when you give what we have just discussed in previous slides, right, or what is the requirement for each and every law, when you have shown all of that, then there would not be a problem. But if you have thought of that, I can create one notice and put it across my GCC region, that will not work. Now, these are not minor gaps that I have just discussed, right? Because these are the exact issues that any regulator looks for during an audit process. If you are able to prove all of these, that yes, you have done XYZ things, only then you are able to prove it in eyes of the auditor that yes, I have taken all of these practices in place, my organization is complying with it, and we can prove it to you as well through these documents, audit logs, etc., whatever we have. Now we have discussed so much about consent. What is it? What does the regulation say? Now let me explain how can and what are the drawbacks and what challenges the organizations are facing. So now let me tell you how you can take those problems and create it into a strategy through Total Shield. So, and this is exactly where Total Shield's consent management comes into picture as well, so that it becomes the part of the conversation that you are having. And I genuinely enjoy it because this is where your compliance is going to meet your requirements. You will be able to stop it from being a burden and actually take it as a capability, that yes, your organization has this capability in place. So what our unified consent management platform was built to do is to solve these issues that we have seen here and to address each of these problems. So what it helps you in doing is that, let me walk you through that very quickly, is that it will help you in governance and role framework. So it gives your privacy teams, your IT teams, your legal teams, and your marketing teams a structured way through which they can manage their consent together. It would be with clear ownership and accountability at every level that you have. Then we do have secure API based integrations there as well, because it will be connecting with the systems that you already have in place. And if it is already in place, then you need something that will sit and connect through the environment. So your CRM tools, your marketing automation, your data warehouses, all of them without requiring any rip and replace need, you can go ahead and fit it into your current infrastructure altogether. Then we do have customizable consent templates and configuration as well. As I was explaining earlier, that you cannot put just one consent notice for all regions, right? So you can configure the consent flows by each and every jurisdiction that your organization is working in. UAE can get one flow, Saudi can get a different flow, Qatar can get a different one, so that you show the notices exactly according to that jurisdiction to the data subject. Each notice is compliant, it will be your complying with your local requirements and can be managed through one single platform here itself, right? Then we have granular consent capture options as well. What do we mean by granular consent capture option is that instead of taking bundled consent as a problem, as I was explaining earlier, you can set consent or your consent notices in such a way that you can put them as different checkboxes at a granular level also and at a sub-granular level also. And then for each and every purpose, you will be able to take separate consent for them. So your marketing emails, your analytics, your third party sharing, all of them will get each purpose and it will get tracked independently for you to see and have a full record of the same. Then we have a centralized audit ready consent repository as well, right? So every consent that will be taken will have a timestamp to it. It will be logged. It will be stored. That you can simply take to the regulator. If they ask you to prove the consent, you just pull out these repositories, these reports, and show them this. Yes, you have these answers ready within seconds. Then we have a full consent lifecycle management as well. So consent doesn't have to just have a start date and have an expiry to it. It can be renewed as well by that particular data subject. It can be withdrawn if they wish to do so. It can be updated. So for that and in that place as well, Turtle Shield can manage all of this automatically. Then we have enterprise-wide compliance enforcement as well. So consent decisions that will be made can be propagated across your different systems. If someone is withdrawing consent or that signal reaches every particular platform and downstream applications in your organization, then you will be able to show that again to the regulators and in your organization as well, that yes, this person has withdrawn their consent and now we have to honor it. We should stop maybe sending them marketing emails or any other for things that whatever might be required. So this helps you in creating a full consent infrastructure. Yeah, this is a dashboard that we have. So you will see that we have timestamps, analytics here. We have various different kinds of reports available. You have your alerts in place. You have your demographic insights in place. You have API usage. So we have various different kinds of uh, aspects and reporting available here for the same. Now let's discuss how consent can be turned into a measurable ROI for you as an organization and not just as a compliance burden. So how do you see it from a compliance burden to actually a measurable ROI? And this is what exactly I want every business leader to take away from this call as well. Because consent, if you are doing it right, then it will not be a cost center for you. It can actually work as a growth enabler for you. So, how does that happen? So, let me connect those dots for you. So, if you have better quality of data, then it will lead you to more accurate and targeted personalization for any particular user. When consent is granular and purpose specific, the data that you are collecting itself is very clean and more relevant and more actionable in nature. Your marketing team will also have better signals that, okay, this person does not need any communication related to this particular service of mine, but they might need it for something else. So you can personalize it that way also. And your conversion rates follow this as well. But for this also, you should take an explicit consent for the same. Then your opt out rates will become lower and your opt in rates will become larger and more meaningful. Your audiences will be engaged more because you have taken the consent properly for them. You have given the notice to them in a clear language, in a plain language. You have made very obvious value exchanges for them. They can consistently achieve what they were looking for. So that will actually turn into higher opt-in rates instead of the consent that is buried in like terms and conditions and transparency is never converted. Then how it will help you is it will also help you in reducing compliance costs and fewer incidents and audits remediation cycle as well. So in case a data breach has taken place, every regulator or investigator that will be coming here would ask for your consent related processes, your remediation, what did you do in case this happened, what were the steps taken by you. So you have all of that in place. You have, because every project carries a cost. It could be financial, operational, and reputational, right? So if a breach has taken place, you should be able to answer that a robust or a good consent framework was in place and it has reduced a lot of the loss that could have taken place. Then it also helps you in stronger customer retention because again you have created trust with that particular customer by giving them all the information that was required by them. You're not bothering them with extra marketing emails or extra services that might not be required by you. You tell them exactly what they need. And particularly in these market and GCC markets, customers are going to trust you more if they are communicated only in this manner. So the customers who are understanding of how they are able to control their data and you as a organization are helping them in controlling their data, they will stay more loyal to you and will have more engagement with you and your brand. Then there is a competitive differentiator as well because, for example, if you are doing this for your customer but your competitor is not, then perhaps you would be perceived more trustworthy in the market where most of the organizations are still treating the consent just as a checkbox and just like a cookie banner. But the early movers in this area would be having a more genuine consent infrastructure in place, and this will give you an advantage over your competitors in your customer relationships, in your regulator goodwill as well, and in your data quality also, that the data that you're holding is actually good. Now, organizations are treating consent as a UX also, right? And just a trust investment. But if you are outperforming them, then again, it will help you in compliance and supporting it also. Now, very quickly, I will tell you the key takeaways that I wish for you to have today. So, what you can do is you can take these steps forward and you can start it as soon as possible in your organization. Is that you use granular consent collection to take consent from these individuals. You break the consent down in certain purposes. Do not bundle it one person, one consent for one purpose. Keep it as simple as that for anyone. Write it in a very plain language. Have someone outside your legal team to read that particular notice. If they are able to understand, then only present it to that particular data subject. Otherwise, go back, improve on it. If you cannot, you should not have to explain it or have to go back and forth with them for them to be able to understand a simple consent notice. Then you should adopt a consent first workflow as well. So consent should be obtained before data processing, which is also mandated in Qatar, but otherwise also if you take consent before processing has begun from that particular data subject, and you have not just treated it as an afterthought, you have not buried it into different unnecessary workflows, then it should be good for you and your organization. Then implement a consent management platform like Turtle Shield with your systems so that you can remove the manual tracking of consent and you can have an automated and scalable structure in place. Then you need to have so that you can have a system of control or records as well. This will also help you in maintaining a time-stamped consent logs because regulators will ask that every consent event should have who, what, when, where, and why answered. All of this will be asked by the regulators, and you should be audit ready for it. And lastly, you should conduct regular consent audits. You should see if your regulations are evolving. You should change your notices that way. If your business is evolving, you're introducing a new purpose, your notice should evolve that way. Your consent framework needs to evolve with all of it, and you should do a regular review for the same as well. If not monthly, then at least annually is what I would say. That's it. That's what I wanted to tell you today. If you have any questions, we can take that up.
Okay, that's great. Thank you so much, Sakshi, for the insightful and highly practical session. Now we can move towards the QA segment. Just a little reminder to all of our audience, if you have not already placed your questions, feel free to submit your questions in the chat box or a QA section. We will try our best to address as much as we can. Okay, so the first question we have received, with increasing use of AI models trained on customer data, how does the consent evolve when data is reused for purpose not originally defined?
Yeah, that's a very good question. Hey, hi everyone. I'm pretty sure Sakshi actually did a covered a lot of topics. So AI models are training a lot on customer data, but they're taking the consent, right? Depending on where you are, geography wise, if you are, so there is a specific thing in EUI Act in Europe, or GDPR has certain automated processing that. But right now, if you see, consent is a very unexplored topic in the whole AI world, right? Just like another securities controls, when technology is like pristine and data is being reused, right? So I'm pretty sure there will be some regulations, but the broad regulation is every data you process, you need to have a consent. Currently, if you see these models, depending on where you are, other than Europe, pretty much they are taking the consent, which is very much preliminary, right? When you actually sign up for the platform, is it right? Not for the purpose of the data, because you don't know, right, how that data will be repurposed. So very good question. Fortunately, I really have a better, but I think all the AI foundational or other major AI companies and their adoption is new. They are just currently we are all basically exposed to it in terms of the usability, but I'm pretty sure they will actually get more clear as we go along, and the better models will evolve.
Okay, thank you so much, me, for answering the question, and thank you, Amar, for raising the question. So now, I think so we can move to the next one. So the next question that I have from Vishnu is, how can organizations directly attribute revenue impact to improved consent strategies rather than just assuming indirect benefits?
Yeah, I can take that one. How can organization directly attribute the revenue impact of the consent? Yeah. So very really good question because security, privacy, uh, and governance, right? It's all about customer trust because if you actually do a proper consent or you take care of the customer data, they're gonna trust you more because if you are basically giving your data with the trusted companies, you get to know, right, where your data is going, where you are getting calls from, or you are getting spam or anything of that sort. It's definitely the customer trust. So privacy is not just about the compliance, but it's about, and that directly attributes to your revenue impact. No matter what, because people gonna trust your data more. That will basically go in increased uh, increased brand impact, and people gonna buy more, right? So it definitely have a maybe direct or sometimes indirect attributes for the increased revenue.
Okay, thank you, Samir, for giving us a detailed clarification. Moving forward to the next question. Okay, so we have the next question from Sana Said. For organizations with highly fragmented legacy systems, what is the realistic approach to implementing centralized consent without
Yeah. So very technical question, and I think that's one of the usually challenge, right? That's why the unified consent management uh, platforms like us kind of exist, right? Because it's fragmented, but imagine the way Turtle Shell works is it actually gives you the APIs to integrate with your consent systems. So no matter, right? So what we are basically doing is integrating with your in-house applications through API or SDK. If you don't have API and it's really a legacy application, we can give you SDK, and that's how you take the consent actually stored centrally from all those applications where your privacy team, legal team, and the compliance team can manage those consent where you don't need to overhaul the systems because consent is just the layer Turtle Shell will add on top of your application, and it's just basically the API integration, and everything will be handled on the other side of the consent, right? So when you actually do probably the honoring of consent, right? If you do opt outs, that actually goes back to the application. So that's the whole purpose of the consent management application and the platform like Turtle Shell.
Okay, thank you, Samir, for the helpful brief answer of the question. I think so. We can move to the next question. Okay, we have the next question from Ira. She is asking, where do regulators draw the line between optimizing consent UX and what could consider dark pattern?
Oh, yeah. So that's the real one, right? So uh, so depends. So there are like depending on how. Yeah, it's a pretty interesting question, right? So I wish I could actually had some examples, but confusing customers, right, and making them sign is not a really not at all a good practice, and there are very specific regulatory guideline on that. Now the consent itself is a UI, right? So it's kind of UI and UX issue. And yes, there can be some tricky ones, and some of the platforms actually do that, right? Depending on where you are. Uh, but regulator do are basically getting more smarter at catching things. But good part of it is eventually your website, your applications, your banking applications, your retail applications, websites, those are pretty visible to the customers, right? So you can actually sometimes get through the dark pattern ones, but people actually, the users also get smarter. So regulators will catch you, right? There when you are basically do, and there are very specific guidelines that dark pattern, but it's not a good business practice, right? To even have those type patterns to confuse you between signing up something which you are not for. So one example, right? There was earlier a kind of a lawsuit or action that you cannot. So you are going to a travel website, And sometimes they make you ask you 3 times, right? Do you want to buy travel insurance? Do you want to buy travel? So once it's okay, right? They're trying to secure your journey and all that, but um, the regulators really actually came back at that you're not say, right? I am risking my travel or whatever, right? So there was kind of a pattern where it was kind of scaring the customers and getting them into the buying the trip insurance or something. That's definitely not a good practice. So it cannot be called dark pattern, but asking that question like 2 3 times, right? It's actually on the similar side.
Okay, very well said, Sameer. The regulator will catch up you. I think so. We can move to the next question. Okay, so Muhammad is asking for beginners in privacy.
So I think Mohammed lost his connection. He'll come back. For the beginners in privacy, what are the most important areas of PDPL to understand first? I think, yeah, Sakshi did cover that in the presentation, but I'll tell you, security and privacy are two different sides of the coin. Okay, so privacy definitely for implementation you need security, but you have 100% security does not mean that you have a data privacy, right? So that's what the earlier slide was. So privacy is like your bedroom or living room curtain where you are actually open it. So it's more about transparency. It's more about you do have access to your customers' data, but how you use it, right? Purpose. So if you see all the kind of data broker platforms, uh, they do have a full security, but not necessarily the privacy. So it's very important to understand the fundamental aspect of that. But if you show PDPL, first of all, you need to have your personal data inventory, right? What kind of data is being used for what purpose? Consent management is actually the one of the biggest area which we just covered. But you start with privacy impact assessments. Then you basically have your personal data inventory. Then you have your data principal rights management. You have your consent management, and then you have your data breach. So it covers quite a lot angle, but I would highly recommend you go on that 6-step plan, execution plan for privacy, which we have put together, and we will actually share social post on that if that helps. But Mohammed, thank you for the question.
Okay, I think so. We can now move to the next question. So, Faye is asking, uh, shaping IT audit and cybersecurity privacy understood differently by everyone. If we want cost-effective and clear consent.
Yeah, so awareness is the big issue in terms of the whole. And if you see, if you go back 20 years back in the security, now privacy does exist for some time, right? So if you go to the government, you go to certain regulatory areas, heavy regulatory like Europe, it's very at least understood to a great extent. However, it is still very, I would say, the under appreciated or under kind of misunderstood area in the region, right? Especially on the east. But understand that there are certain different parts of the privacy, right? The way you will have the privacy in this part of the region is different than how that, right? So there are things like biological privacy, there is online privacy, so it's a really interesting purview in terms of uh, the the regional. So there are regional aspect of it, right? If you're talking about what is how people respect their privacy, right? Whether it's bodily privacy or if there is basically how you the online part. But mostly, if you see these platforms, right, which are actually using your data, the purpose you are using data, so consent becomes really critical, right, for that. So it's not just a checkbox, and that's what our topic says, right? Um, Now, technically, you have to make the job simple for your users. But at the same time, you don't need to force them into accept all, right? So the concept is nutrition label, right? So just like you have a nutrition label for your food items, privacy should very easily understood. And actually, the regulations do require you that it has to be simple understood. You're not throwing the whole page of privacy notice and hey, go accept. So that's how you basically achieve it.
Okay, thank you. Very well said, Samir. I think so. We are good to go from the today's session. As we come to the end of the today's session, I would like to extend a sincere thank you to our speakers, Sakshi and Samir, for sharing
Hey, thanks
such
for having us.
well,
Yeah, thanks for
valuable
having us,
insights,
Mohammed.
and
And
everyone who joined us. So the one key takeaway that we can take from the today's session is the consent is no longer just about compliance. It's a strategic tool that we have right now that can drive trust and measurable business values. Thank you once again for joining us. And we wish all of you to stay compliant and stay informed and most importantly, stay ahead. Thank you, everyone. Have a great day.
yeah, have a great evening. Bye bye.
Thank you.